It's kind of the end of the technical talks this morning, and then we'll move on to a panel discussion on the legal dimension of security for space. The panel will be moderated by Yacine Felk from CYSEC. He will be broadcasting live from Lausanne with four participants touching about the sensitive topics of the applicable laws. Is there any international regulations that are applicable for spacecraft? What's happening if a spacecraft gets hacked? Who is liable? What are the typical consequences? Can you go to court? Can you go to jail if your spacecraft gets hacked? Any previous cases that we can put forward, and so on and so on. It's a big topic. I got the green light from the team, so let's welcome Yacine and the participant. Hello, good morning. Are you with us? Hello, Yacine.
Hello, Mathieu. Good morning. Thanks for the introduction. I'm very delighted to start with our panel related to cybersecurity and legal in space and all the consequences, as you mentioned. Mm-hmm. So, if I have your green light, so we start just right now.
Yes, just before you start, I just want to mention that we're sorry that you couldn't be with us in Davos, but the COVID regulations made it hard to have any people on site, so we kept the team as minimal as possible. But hopefully next year at CYSAT 2022, you, the participants and the speakers will be able to join physically for the event. So thanks a lot for being online and for moderating this panel.
Yes, definitely. We are looking forward.
Excellent.
So let me introduce first my colleagues that I have here during this exciting panel. So first, I would like to introduce Rada Popova, who is graduated from law faculty of the University of Vienna, and currently she is working as a senior research fellow and lecturer at the University of Cologne. As a lawyer, she has provided expertise in many topics related to aerospace projects with ESA, the German Aerospace Center, and many industry stakeholders both in France and Germany. She co-authored a book related to legal aspects of cybersecurity in the aviation and space sectors, which was published in 2019. And she contributed for sure to many works, both academic and research, related to International Institute of Space Law on cybersecurity. Thank you, Rada, for being here. I'm going to introduce also our second panelist, who is Dimitra Stefoudi, who is part of the academic staff of the International Institute of Air and Space Law at Leiden University. And she's working most of all in space law. She is also visiting lecturer at the International Space University and co-chairing the Policy, Economics and Law Department at the ISU Space Studies program. I'm very glad to have you here. Let me also introduce our third panelist, who has both industrial and academic affiliations. Dr. P.J. Blount, who is a research fellow in cybersecurity governance and regulation, both at SES and University of Luxembourg. I'm very happy to have you here, as your research is funded by an industrial fellowship grant from the Luxembourg National Research Fund, and you are also an adjunct professor in the Air and Space Law at the University of Mississippi School and Law from 2017. Last but not least, in the panel list, I would like to introduce Efrén Díaz, who is a lawyer and doctor of law and senior associate at Massey CALVET law firm based in Madrid, acting as head of technology and space law areas. I'm sure that you will bring a lot of background regarding to applicable law, what is foreseen, what is missing, applicable, and all the challenging aspect of it. So if you allow me, maybe we can move on with the discussion, questions, and start the panel, going from general questions to more specific ones. So maybe we can start with you, Rada, explaining us or giving us background on what does international law tells us about cybersecurity and space in general, and then we keep the discussion and see how it goes on. Thank you.
Thank you, Yacine. I'm happy that the technology is working, and I hope that this panel discussion will bring some interesting insights for all technological experts on the legal side of things. Although the law, I think also the other panelists could agree, unfortunately still has to say less about cybersecurity than technology does. But starting with the overview on what international law has to say about cyber and about space law, we can divide simply the two topics and state that while there is a legal field or a body of international law that specifically regulates outer space as a domain of human activity and regulates also the use of human-made objects and human specific activities in outer space, in contrast, in cyberspace, we do have a general applicability of international law, but we still do not have specific or many specific regulations on cyber activities or on the use of cyberspace in general. And this is an emerging field of law. So I hope that the pace with which technology is developing will also lead to some more developments on the legal side. And Yacine, do you want me also to say what the relevant specific law to outer space is? Do we need that overview?
Yes, definitely. If you have some insights to share, that's very welcome. Yeah.
Good. I'll give a brief overview. So generally, the current binding legal framework on space activity, space activities emerged already back in the 60s and the 70s in the framework of the United Nations. So as a result of this, within 12 years, 5 international treaties on space activities were produced. And since 1979, instead of producing binding law, numerous non-binding so-called resolutions or declarations have emerged on specific matters, such as, for example, remote sensing, broadcasting through outer space, later on in the more recent years on national space legislation. But as I said, we have a level of binding space law and numerous non-binding treaties on the international level. And then additionally, we do have national space legislations. If I'm not mistaken, almost 30 states nowadays have their specific national law, which regulates the activities of private companies and the state in outer space. And as far as the cross-section between outer space and cyber is concerned, we do not have a specific, neither international nor national, very detailed framework which specifically would regulate cyber activities within the space domain. There are some efforts, and I'm sure we'll come to them during the discussion.
Thank you very much, Rada, for these first comments and insights. So it brings me to another questions when talking about the industry, let's say, and what are the best practices, and maybe here, Peji, you can bring some inputs. What is key finally in securing space assets regarding cyber attacks? What can you provide as, let's say?
Well, so I'm of course going to answer this from a legal perspective, and I want to follow on what Rada just said, is that there's just not that much law, but we can sum it up, right? Because, you know, I can sum up cybersecurity law in "thou shalt be cyber secure," but we don't really know what that means. And so as a lawyer working in an organization, you have a critical role in making sure that you can show that you are cyber secure enough, right? And I call this the CYA principle, the cover your ass principle, to be a little crass there. And so as an attorney within an organization, you have to think about several things, right? One of these is that risk assessment that's going to have to be done, being able to advise on legal risk of, is my camera freezing up there? Sorry. So you have to be able to advise on the legal risks that are going to confront the company. And this can be all sorts of legal risks. And I think one of the ones that we can all focus in on is GDPR, right? It's about personal information and the need to keep personal information private. It's not necessarily a cybersecurity law, but that's definitely going to impact the systems and how they're designed. So as the information security team is working on designing a system, you need to be able to advise them on what information is going to have to be kept more secure than other information. You're going to need to make sure that these cybersecurity duties that you owe both to shareholders as well as to vendors and customers are written into contracts and passed along to your contract partners so that the breach doesn't happen down the line and you're on the hook for it. And then at the end, in case of an action, whether it be a criminal action or a civil action or an administrative action of some sort, you need to be able to show up with evidence that shows that you were doing the things that you were supposed to be doing, right? I think that we all know that no system is ever completely cyber secure. But if you were acting as a reasonable party and you were acting as a reasonable business in this, if there's a breach, you should be able to show up to court with a stack of evidence that shows that, yes, we encrypted the personal information on this drive, authorized our boundary properly, and all these things. And this obviously means that you have to work closely with the information security management team.
Thank you very much, Paige, for your insights. So it's very clear that cybersecurity, protecting space assets is really a kind of insurance that every company needs to adopt and to ensure that they comply, in order to show that they comply with the different regulations and rules. So maybe, Efrén, on your side, you can give us some highlight some points regarding how law protects us against cyber attacks in space and the main regulatory protection tools that a company can leverage on.
Thank you so much. From my perspective, I would like see this topic from the perspective of having to use today or tomorrow a cyber attack. So I would like offer you 4 lines to understand this. First, Earth versus space. Second, technology versus legality. Third, preventive versus reactive actions. And fourth, security versus privacy. I agree with Rada and PG about their scope, but just to go inside of some details of each of these 4 points, I would like to offer some background. Earth versus space means that what happens in space is organized from Earth, and that's the approach. So tomorrow, if today we have a cyber attack, tomorrow we are in a court. That's our rule. So our Earth rules. Second, technology versus legality means that many times technical approach doesn't match so well with legality approach, because technical is something operational, but legality is in contact with the right of the people, the right of the company. So is not a direct relationship. So when you want to protect against a cyber attack, we must think in both sizes. Why? Because preventive actions, from my point of view, must protect at least the 4th dimension of the information: availability, integrity, privacy, and security. That's technical, but it's connected with legality too. Because reactive actions means, as PG said, civil, criminal, and administrative actions. But the problem in these legal actions today, especially in a space area, is the slowness, complexity, and burden of proof we have to deal with to defend against a cyber attack. And finally, the distinction between security and privacy. Many times, especially in the application of GDPR and similar rules, in my experience, many people confuse both as the same, but security is a technical dimension, meanwhile privacy is a legal dimension and is affecting people's rights. So infringements on security perhaps doesn't mean the same as the infringement of privacy, which is implying sanctions. So what are the main regulatory protection tools? To be summary, be careful about preventive actions more than reactive actions. Protecting from Earth what you do in space, especially is in relation with information.
Thank you, Efrén. I think it's very valuable for everyone in the industry to kind of be reactive when talking about cybersecurity concerns and its legal consequences, and be prepared to what can happen. Most of all, because as we all have seen, NATO has declared space domain as an operational domain, just like as you mentioned, ground and all the operation that can have on it. Maybe Dimitra, you can highlight us on the agenda which is related to this aspect, and mentioning how countries are behaving with regards to this specific part.
Certainly, and with that, I would like to move the discussion a bit from the level of private actors and companies to the level of states, and from law to policy, since NATO is mostly based on that, on standards and procedures that secure the collective defense of its military alliance. And indeed, at the end of 2019, it declared space as an operational domain, along with air, land, sea, and the cyberspace. This is one of the occasions where we see cyber and space being within the operational scope of the same organization. But unlike space and the rest of the domains that we can actually see and understand where it is, it's not the same with cyber. That's an intangible dimension. With this declaration, NATO, first of all, acknowledged the military aspect of space activities and space operations, but also the role of space assets in its mandate in protecting, defending the interests of its allies. According to NATO, and this is what brings us to the question, what could NATO do? What does it mean to have space as an operational domain? The North Atlantic Treaty says that any attack against an ally can prompt a defense, is an attack against all, it can prompt a defense from one or more allies. What does this mean? If there is a cyber attack to a country, to an ally, does it prompt a cyber defense from the rest of the countries? And if there is another sort of attack, can countries respond with cyber attack? Can it escalate to a space-based conflict? And how far will NATO go to protect its space assets? Those are questions that are currently being considered since NATO declared outer space as an operational domain. What it's mainly trying to do is not weaponize outer space. NATO has specifically mentioned that it will follow a defensive approach in accordance with international law when using space assets. So the main goal is to integrate and somehow make interoperable the space assets of its allies. NATO does not have its own capabilities. It has to rely on the assets of its allies, which brings along some more questions regarding its structure. Perhaps this will allow NATO to ask countries to offer their space assets for the purposes of the alliance, to enable perhaps some of its existing military operations with space capabilities, so not necessarily using space assets for defense, but using them to support other ongoing operations. And in this regard, there are many uses we can find for space technology, from communication, navigation, surveillance on the ground, and so on. On the most recent developments in NATO, First of all, NATO has introduced a discussion on the war-fighting capstone concept, if I get the termination correctly, which describes the future character of war, which includes, without explicitly mentioning cyber or space, it includes a lot of extensions. And it pursues in this regard a cognitive superiority. NATO wants to be ideally in front of all the developments using space assets. And thinking about that, how it can obtain this cognitive superiority is the point perhaps where space and cyber connect, because it reveals the cyber vulnerabilities of using space assets within the framework of NATO and using potentially space assets to counteract cyber threats or to conduct cyber threats for defense or NATO purposes. So this is more or less what is happening at the moment. It's an ongoing, of course, consideration, but I think it's introducing an interesting parameter. NATO is obviously towards more the military aspect, not much the civil discussion on cybersecurity and space activities. And it highlights, of course, the fact that as the term privacy that we mentioned, cybersecurity is always considered a bad thing. We never hear cybersecurity and feel secure. We always think about a threat, an attack, or some sort of incident.
Thank you very much for giving background to all what's happening under this operational domain space. And here I would like to take on thank all of you to thank all of you for your inputs and contribution, and have to take a little bit the discussion further to understand how space is considered in law as it is outside the sovereignty of any specific country, and what does it implicate for all the value chain in the industry, both from a practical, let's say, and a research perspective. So who wants to start, maybe? Rada, yes, please.
I can start, but please interrupt me if the others want to take over. Well, the most fundamental fact here about outer space in legal terms is that it is a so-called area beyond national jurisdiction, or an international domain. So it is a nature-made, so non-made domain in which national sovereignty, and with this national jurisdiction, does not extend as it does, for example, on national territory. With one exception, when we talk about man-made objects and persons in space, so when we talk about satellites, space stations, and people on board space objects, these are the types, let's say, of objects in outer space upon which state jurisdiction applies. So basically, states are under certain limitations because of this international nature of outer space. This means, from the legal perspective, first, that space activities, or the domain as such, are subject to international jurisdiction in the first place, which means that national interests or national disposition with legal rights has to be in accordance with international law, and also has to be in the accordance with the many other coexisting equal national rights. So states are free, for example, to regulate over their space objects, over their space activities, and over their persons. But they are not free, for example, to regulate over orbits as such, unless they do so within an international forum such as the ITU, as we know it with the geostationary orbit, or other international forums such as the United Nations Committee on the Peaceful Uses of Outer Space. So this is why we have this two-tier approach to outer space. On the one hand, it is an international common field where national rights are actually subject to the principle of equality. So no state is actually allowed, in exercising its freedoms to use outer space, to restrict the freedoms of others in also using it and exploring it. And this is where actually also the topic of due diligence, which PJ also talked about, comes into play. You are free to use outer space, but at certain or under certain limitations, including the due diligence or due regard principle, which is also included in the Outer Space Treaty. So this has an important role for every type of space activity, but also coming specifically to cyber activities when we talk about managing the risk that something goes wrong in outer space because of cyber vulnerabilities. This is where potentially states, for example, could not only be threatened themselves, but also become a threat, or let's say not only states, but space actors in general, if the interests or the rights of other states are impugned.
If I could maybe follow on to that real quick. One of the ways that I like to teach this is to think about space law as actually being addressed to space objects and space activities, right? And then if we think about cyber law is addressed to networks and systems. And so we have to think about that intersection of where these two things intersect. And obviously, as we are moving into more advanced types of satellites, we're seeing that the network technologies that drive the internet and cyberspace are now being implicated into satellites. And so, it's not so much that space sits outside of sovereignty, as Rada very clearly stated. There is still some sort of authority, some sort of jurisdiction over these craft. But when we think about it coming back into cyberspace, we end up with all those transnational effects that we're very familiar with in cybersecurity and the terrestrial domain, and they just get amplified to some extent in the space domain. And I think the other important thing, and this links very much to what Dimitra was talking about, is that space is a strategic domain. And so your risk profile is very different there, right? It's not just your private computer that's sitting at your company. It's actually a computer or a satellite or a system that is on orbit in a strategic domain. And there is the possibility for a hacker to cause that system then to interfere with national security issues and international peace and security issues. And so that adds this extra layer and this new dynamic to it.
In that point, from the practical perspective, I agree with Rada about the space objects outside of the ground. But today, the strong connection between Earth and space, especially in cybersecurity, means many times take actions on Earth, because in fact, what is really protected is what is outside of the atmosphere, because it's outside of the hands of the people, and many times it's outside of the scope of the hackers. But in terms of cybersecurity, the real actions must be taken on Earth, on the servers, and also in the information flows of your company or your activity. And these days in Spain, we are suffering the cyber attack on the labor system and crash all the national system. So in comparison, it doesn't mind if the information is on an Earth server or is from a satellite, because at the end, our system, at least today, is based on what we do on Earth with the help from objects outside of the atmosphere. But anyway, in that point, I would like highlight the importance of impact assessment, as PG says, and think in terms of what happened today if I lose all the information I have, and take actions from the practical understanding of your specific activity. It's not the same lose just one satellite or lose your servers, or imagine be hacked by ransomware and lose not the connection, just lose the package of your information. Are you lost in that case? So take actions to solve that and think from the practical understanding of what you are doing. Otherwise, theoretical reasons can be applied, but tomorrow you must continue with your activity. So if you lose it today, what are you going to do tomorrow?
Thank you, Efrén. I just would like to mention to our attendees that they can ask also questions in the chat. So feel free to do so. I will be more than happy to submit them to our panelists. So the first one is coming from Florent, asking if there is any timeline for releasing a common on or international policy for the cybersecurity of space assets. What do you think?
No, not at the moment. In my understanding, what's the main rule now is the international data transfers with the impact of GDPR and its implication. And I don't know if Rada or other ones know it a bit more, but it's a complex issue today, and is the lack of regulation to go to court tomorrow, in fact.
I mean, even if we talk generally about the regulation of cyberspace, there is so far just one binding international instrument, which is the Budapest Convention on Cybercrime. So we are not even far ahead in regulating cyber in general. And we're much less far in regulating cyber activities and outer space, or this very important intersection. And I would just like to echo everything that also Efrén mentioned, and Dimitra and PJ. This is why, but I think this is also obvious, and it became obvious also throughout all the presentations. We talk about cybersecurity of outer space because we know that the big value in outer space are not just the assets there, but the data. And the big value is our, or the counterpart of this big value is our vulnerability. We are totally dependent and increasingly dependent on using this infrastructure. And in fact, because we are actually able to do what we can do for prevention only while the objects are on Earth, we are quite restricted in protecting our data and the space infrastructure which submits this data after it is already out there in orbit. So it seems that the law is not the first thing to undertake, or the legal steps are definitely not the most pragmatic approach. First, it has to be thought in technical terms. What are the best means to ensure at least the best possible prevention, because complete prevention is not possible. And then how to do, what kind of redundancy you need to make sure that even if something goes wrong, even if your signals get lost or your data gets corrupted or stolen, that you have some redundancy, both in terms of infrastructure, but in terms also of data. And the law here can only echo these technical parameters and try to put them through helpful regulations. And this is something we have not, I think, yet mentioned, that the International Telecommunications Union has also seen itself as a proper actor in helping states, for example, to work on their national space strategies. So we're not yet talking about binding law, but at least we're talking about an international effort which should help states to develop adequate national cybersecurity strategies, which at the moment exist for certain states, but definitely not for all states. And so far we have a rather fragmented systematics of these policies.
I think what is also interesting to mention is, if we're wondering what's the timeline, do we expect a regulation? We have very recent regulations on cybersecurity, and I have in my mind the EU directive on network and information systems that's been enforced for a couple of years. And I would say completely disregards the interdependence between cyber and space that we have been explaining so far. So even for the regulatory pieces that are now coming up, I'm not sure whether the role of space technology within the network and information technology has been understood. That would solve perhaps a few issues, because we do think of space, and rightfully so, as critical infrastructure, but the cybersecurity regulations that protect critical infrastructure do not always include space technology among it.
And by the way,
Well, sorry.
I'll jump in just with one sentence just to
Go ahead.
actually support what Dimitra said. That's absolutely true. Not only the EU has been working for almost a decade now on cybersecurity in general, on the security of data content, but without focusing on space yet, but also so has done also the OECD, also UNCITRAL. They have some cybersecurity related instruments, but none of them is actually focused on space.
What I was going to add is that, you know, when we're talking about international action on this, we have to remember that the geopolitics right now are just fraught. If we look at all the major actors, they all have very different conceptions of what cyberspace is and how it should function. And I mean, all the major actors, even between the United States and the EU, which are allies, there are really huge divides on how cyberspace should be controlled and who has that authority and how that authority should be used. And so, I mean, if we're thinking about the hope of some sort of international instrument on cybersecurity in the space domain, I would say don't hold your breath. You know, we can't agree on basic security documents for the space domain outside of cybersecurity. And as Rada and Dimitra pointed out, we can't agree on these at the international level for just cybersecurity in general. Adding the two together is just, it's just not in the books right now, or in the cards right now, to get the metaphor right.
Thank you, Paige. So I don't know if there are any other questions from the attendants. That you would like to address, or any other point from the panelists that you want to stress, or any detail we missed?
Yes, I would like talk about the vulnerabilities and what can we do in those cases. In my professional experience advising companies in the space field, I realized about two problems in the base in corporate issues and insurance issues. In cybersecurity, the complexity of the infrastructures and the information and the data require the connection between different companies. So from our point of view, it's very relevant and be sure about the contracts you sign. Otherwise, the flows of information can be missed. And sometimes you don't really know who is acting about what. So corporate issues and the contractual relationships are very important. And second, in cybersecurity, I realize, at least in the European framework and also in US, the perhaps misunderstanding insurance coverage, because sometimes they call cyber attack insurance. In the mind of our clients, they think, okay, if I suffer a cyber attack, someone else is going to pay me the damages. But the problem is when you read the small letter of those insurance contracts, you realize about two main problems. First, what are they covering? Not the damage, just the economical loss. So that's very tricky, because how you prove the economical loss about your active, your systems, your infrastructure? Just the cost of the damages, the lack of redundancy and the problems in your activity. That's a big problem in terms of proof and forensic evidences, etc. But the second problem in that point is the exclusions, because I've been reading some contracts recently about cyber attack and cyber protection, and they say the main exclusion is the voluntary action of the people in the company, and second, the lack of measures, technical and legal, to avoid cyber attack. So with those exclusions, in fact, I'm not going to be covered anyway, because usually the problems of cyber attack are not known by the people, and the lack of measures usually is the real problem you have, because you don't know how the bad person, how the hacker is going to attack you. So from those sides, object and exclusions, the insurance cyber security is not applicable in practical terms. So we are fighting about that.
Thank you, Efrén, about highlighting the importance regarding the contracts, the clause of exclusions, and also the liabilities. So maybe there is one last question regarding policymakers and public policies, and this resonates with what Florent asked in the chat. Basically, whether do you think that the heterogeneity coming from the legal frameworks all over the world between the different countries, basically, or the regions, can give a competitive advantage to a specific one, which shows weak interest in those kind of regulatory procedures?
I hope not. I don't know if the rest agree with me, but if I understand the question correctly, if a country has weaker thresholds, maybe this gives it a competitive advantage, because if we establish ourselves there, we don't have to take that many measures. But the main issue with cybersecurity is that you are benefited if you follow very strict measures. The entity itself is benefited. You don't need the law to tell you that, because if you do suffer the damage, and that relates to a very nice point made by Efrén, if you do suffer the damage, if the approach is reactive, little can be done. You will get some financial compensation, but your signal will be interfered with, your data will be leaked. We have to focus more on the preventive, which is a good part. It's good if countries do have a higher threshold of cybersecurity protection.
Yeah, I also would follow in on that. I agree with Dimitra there. And I think that this actually also goes to Efrén's comments there. It's that, yes, you can forum shop and you can go somewhere where they have weak regulations, and you can then make yourself a target, because hackers are going to know that you're vulnerable. But the other effect of that is it's going to be very difficult for you to have contract partners. Because these contracts are going to be written that you need to show that you were cyber secure, that you had the policies in place, that you had the proper certifications in place, that you had these things in place. And if you're taking advantage of forum shopping for weak cybersecurity laws, then it's going to be difficult for you to contract at the multinational level, and that's going to be problematic for your business model.
Okay, so thank you to all of you for this panel. I think we had a lot of interesting ideas, insights, and recommendations with regards to activities in space.
Yacine, can you hear us from the studio?
Yes, I can hear you.
Yeah. Thank you, guys. Great panel. We actually have a couple of questions with Patrick here. I'll just phrase your question, Patrick. You mentioned what are the programs or the schools offering education combining cybersecurity and law? Does that exist today?
Yes, at least in Spain, we have a very modern regulation after GDPR, and they foresee the right to teach about technology from very early stages at the school. It's a very fascinating digital right, especially foresee at national level. And I know other countries are doing something similar, like Italy and others.
I would also note that myself, Dimitra, and Rada are all at schools that combine space law and cybersecurity law to some extent within our programs. And so there's even work on the idea of space law and cybersecurity law coming together through these types of programs.
Okay, thank you very much. Maybe one question to you, PJ, since you were the last on the screen. Can you explain us what are your activities at SES? I'm just interested to know what are the legal activities at a satellite operator. What do you deal with on a day-to-day basis?
So let me clarify what I am. I'm a research fellow, so I'm funded by the National Research Fund, and I split my time between SES and the University of Luxembourg. So I'm going to speak generally here because I don't intend to be speaking on behalf of SES. When I'm at SES, I'm embedded with the legal team, and we look at all sorts of different things, and that includes contracts, it includes data protection issues, it includes forward thinking on what types of controls are going to need to be implemented on future systems that are being developed. So from the legal perspective, there is strong cooperation between the legal team and the information security team to ensure that the security team understands the risk that comes from the legal side, and also to understand for the legal team to understand the types of technologies that are being implemented from the technical side.
This is why security is such a fascinating topic, especially for space, because it is very technical. And as you just pointed it out, it's really the merge of understanding the technicalities of the threats, of the solutions, and all the other non-technical issues. Do you yourself talk sometimes with the engineers or maybe the people from the panel? Are you familiar with the technical topics that we will be talking about today? Like we talked about cloud, quantum. Do you follow also these topics?
Yes. Yeah, let me to just put an example. Tomorrow we are going to finish a deposit of the software code in a notary to prevent hacking. So we've been dealing for a few months, packaging all the software, all the functionalities, all the versions all together. And just tomorrow we are finishing that project to present into a notary, just to keep that not only for IP protection, also to prevent cyber attacks. So all this, like in another hard drive, deposit officially, just to protect it for future projects. So the problematic we find more is the connection between lawyers and engineers to match on that kind of projects. It's a fantastic way of working, and also in the future the problems of burden of proof in court. This is a heavy problem when you have to show to the judge what happened on a cyber attack. In my experience, it's very difficult, and you have to trust on the experience and professionally of your engineers and your technical teams.
Great, thanks a lot for the very interesting anecdote. Going to the notary with a piece of code. I don't know if you've seen that, Patrick, in your career.
No.
Great. I don't know if you have one last word, or Yacine, maybe if you want to wrap it up, and then we can take it back at the studio.
Yes, sure. Thank you, Mathieu. So we were, I think, managed to have a great conversation regarding to the intersection between law and space and cybersecurity, with great insights on one side from a practical perspective as well as the international policy. So I'm looking forward to the rest of the CYSAT conference, and we leave you there basically.
Great, thank you.